Good morning. My name is Saeed Sims I am the director of the Diverse Business Support Services Center at Cheney University, and today we'll be discussing contracts. Today's topic will include what is a contract, the elements of a contract, the players, the offer, the acceptance, the consideration, statute of frauds, breach, and damages. What is a contract? Black's Law Dictionary defines a contract as a binding agreement between two or more persons which creates the obligation to do or not to do a particular thing. A contract is an agreement that a court will enforce, and contracts can be verbal or written. We'll get into the strength and the validity of both verbal and written contracts later on in this presentation. But know that the key elements here are that a contract is an agreement that the court is willing to enforce. There are several agreements that can be made. However, some of those agreements cannot or will not be enforced by the courts, and we'll go over those as well. So, what is governing contracts? So let's look first at common law. Common law is really case law, or law that has been decided by previous judges in the past, and that sets the precedent for following cases. And then we have the Uniform Commercial Code, Article 2, which is what governs the sale of goods and other commercial transactions. So let's look at the players to a contract, okay? So we have the offerer and the offeree. The offerer is pretty much the person who extends the offer to the offeree. They set the precedent with the parameters for acceptance. The offeree is the person who the offer is made to, and the only one who has the power to accept the offer from the offerer. So let's take a look at the offer. All right? An offer is what gives the power of acceptance to the offeree. Okay? It has essential elements that needs to be contained in it in order for it to be considered an offer. Usually, it is the definite terms that is what makes it an offer. For example, if an offer says to you, "I'll sell my scooter for $400," that has a level of definiteness to it. It has what's being sold and for what cost it's being sold. Um, Usually, that's what are accepted in the parameters of a standard offering. Then that offer is valid, right? So then let's take a look at the acceptance. Now, an acceptance can only be accepted by the offeree. Okay. The acceptance, in order for the acceptance to be, or the offer to be accepted, it must be legal. The person who accepts must be of sound mind. Um, that means there can be no intoxication or duress, and they must be of the legal age. Now, with regard to acceptance, okay, at common law, there's the mirror image rule. And what that means is that the offer must be accepted exactly as it's stated to the offeree with no modifications. Any modification that is made by the offeree no longer makes the offer valid, and it creates a counter offer for the offerer to accept or reject. Now, the Uniform Commercial Code on Acceptance is a little different than the mirror image rule because it's not governed for the sale of goods and commercial items. It's not looked at common law, and so contracts between merchants looks a little different. So any manner that shows agreement to the contract. An example would be words, actions, or writing can be construed as acceptance. For instance, if I had agreed with you uh, previously when we met to buy or to sell you 300 widgets, and I send you 400 widgets, your acceptance of the 400 widgets without there being any refusal um, would then count as acceptance of the additional 100 widgets, and a contract will be formed based on what I sent to you, not what we had originally agreed upon. And that's the difference with the acceptance with regard to the sale of goods versus at common law. So let's look at some of the elements of the contract. One of these would be consideration. The consideration is really what is considered to be bargain for exchange. The value determined by both parties to be exchanged for in the contract. So again, on the example that I provided with the scooter is consideration for the $400, which is also consideration. In that example, those are the two forms of consideration that are considered bargained for. Now let's look at the statute of frauds. Now, as I said before at the beginning, not all contracts are written contracts. Some are verbal contracts. But there are certain contracts that must be in writing, and those contracts are governed by the statute of frauds. Those contracts are contracts for consideration of marriage, contracts that cannot be performed in 1 year, contracts for the sale of land, contracts for the sale of goods totaling $500 or more, and contracts in which there is a surety or a to pay the debt of another. Now we'll look at breach of contract. So breach of contract occurs when the agreement is not kept between either party or by either one of the parties. And so a breach can occur if a party fails to perform within the time frame specified by the contract or does not perform in accordance with the terms of the agreement or doesn't perform at all. And so if one party fails to perform underneath those circumstances, it will be considered breach of contract. And under that, the law does entitle the party that has been injured by the breach certain remedies. These remedies are considered or called damages. So one of the damages are considered in restitution would be a compensatory damage, and this is a legal remedy that says that a court can order the person who breached the contract to pay the aggrieved party enough money to get what was promised in the terms of the contract. Then there's a restitution. In the restitution damages, a court can order the breaching party to pay back the other person's amount that the aggrieved party initially made to make the aggrieved party whole. So in that case, that would then make whole the aggrieved party. And then there's punitive damages. If there's a breach of contract that is so out of bounds or so-called so heinous, the court can order punitive damages or punishment uh, for the breaching party. And then last, there's specific court performance. And what that is that a court can force the breaching party to perform um, the service or deliver the goods that were promised in the contract. And so we hope that this brief overview of contracts has given you some understanding of what an agreement is and what some of the legal ramifications of breaching the contract are. I want to thank you again for your time. And if you have any other questions, our contact information will be included along with the end of the program. I want to thank you again for your time and have a good day.